Good morning, everybody. I am Jackie Goldberg. I am co-chair along with Mary McGuire-Weaver of the Manhattan Family Support Services Advisory Council. We are co-presenting today with Tina Vale from the Bronx Family Support Services Advisory Council, and also with Andrew Harris and Pat Liu from the Transition Committee. So we're very excited. We have Stephanie Barron, who is an attorney and head of the Guardianship program, future care planning program at AHRC. And we're very happy to have everybody here this morning. We know this is a very important topic, especially at this time of the year when a lot of people are looking to transition out of school, and you want to make sure guardianship is in place. So today is going to be a general overview of 17A guardianship, which is classically what most people think of guardianship as, but there are also alternatives, which Stephanie will be going over, such as supportive decision-making, healthcare proxies, powers of attorney, and representative payee. So as I said, today will be a general overview, and then in 2 weeks, we hope that many of you will join us for a step-by-step going through the paperwork of how to actually do this application. It is going to be a hybrid meeting. It's going to be in person and on Zoom, and we will have Spanish translation. Oh, and thank you, Johanna Santana, for providing Spanish translation. We really appreciate it. And without further ado, I think we'll get started.
So we're going to be talking about guardianship first, so what you need to know. So the law does presume that once a person reaches the age of 18 that they're capable of making their own decisions. However, for some individuals with intellectual and developmental disabilities and other conditions, they might still need the assistance of their family members and friends. So guardianship is the legal process that's created by statutes that provides family and friends that legal authority to continue to advocate for their child or their loved one and their needs. So it's important when we start thinking about guardianship that we think, is guardianship really necessary? Because there are alternatives to 17A guardianship, and it might not always be appropriate for your child or loved one. It does depend on their individual needs and limitations. So the first consideration is whether your child or loved one can make decisions and manage their daily affairs and what that actually looks like. Specifically, when it comes to activities of daily living, what do they need assistance with? What can they do on their own? Are they able to travel on their own, manage any money, make change? And then, of course, the most important aspect, medical decisions. So, is your child or loved one able to determine when it's necessary to see a doctor? Are they able to schedule and attend medical appointments on their own and communicate with the doctor? So, and while it's important for us to consider this while we're in the process of thinking about guardianship and alternatives, this is also what the judge is going to be looking at during the guardianship hearing, specifically the ADLs and the medical considerations. And like we said, there are alternatives to 17A guardianship, and we'll go through them. So, supportive decision making. So, there's a practice by which people with intellectual and developmental disabilities are able to make their own decisions with the support of trusted people in their lives. And Governor Hochul did sign Article 82 of the Mental Hygiene Law. So we have our legislation that legalizes the supportive decision making. Um, which so it does recognize that supportive decision making, both informal and with the supportive decision making agreement, is a less restrictive alternative to guardianship that the court should consider before imposing a guardianship. It also requires third parties to accept decisions by people who have a supportive decision making agreement that is a legal binding, technically, I guess, contract for Okay, so we were talking about how the supportive decision-making agreement, we do have the third-party legislation now, which requires the third parties to accept decisions by people who have a supportive decision-making agreement that's been entered into through this facilitation process. It is going to be legally binding.
There.
So we do have that in place now. And this hopes to incentivize parents to consider and choose supportive decision-making agreements as an alternative to guardianship. Okay. A representative payee. So this is a person or an agency that's designated to help a person with a disability manage funds that they might receive from public benefits, such as SSI. So it's an alternative, but it's also something that you might need to also do if you even are the legal guardian of someone. So if you want to help manage your child or loved one's public benefits, you would have to contact the Social Security Administration to become their representative payee. It can only be done through the Social Security Administration, and it does allow you to manage and access those funds for the benefit of your child or loved one. So even if you are appointed the guardian of your child or loved one, and if you do want to help manage the funds, you also need to become the representative payee as well. So a healthcare proxy. So a healthcare proxy is an agent that's designated by a person and who has the authority to make medical and healthcare decisions should a doctor declare that person unable to make their own healthcare decisions. Um, it's a good idea for everyone to have a healthcare proxy just in place. Just never know. We have the link there we can share with the actual form of a healthcare proxy. You don't need an attorney. It doesn't need to be, it just needs to be signed in front of two adult witnesses who are not going to be the healthcare proxy. So it's relatively simple to complete. Whereas a power of attorney is a legal document, and it does allow a person to act on as an individual's agent on their behalf. In New York State, it's generally only used for financial affairs. It can never be used for medical or healthcare decisions in New York State. New York State, it must be the healthcare proxy. So really a power of attorney in New York State is for financial affairs and not medical or healthcare decisions. But it's an option if your child or loved one has property or funds that need management outside of public benefits. And then, just since we are doing an overview, I think it's important to know that New York State does have two different guardianship statutes. So Article 81 is pursuant to the mental hygiene law, and that allows for the appointment of any person who's found to be incapacitated or in need of a guardian. So it could be an elderly person with dementia, could be somebody with mental health concerns. It can be used for people with intellectual and developmental disabilities. But Article 81, in theory, can be limited and tailored to meet the specific needs of the person. And they're filed in the Supreme Court. And you start that filing process by filing an order to show cause, and it does have a $210 filing fee. And generally, you are going to need an attorney for this type of guardianship. It's just a little bit more complex and complicated when you compare it to Article 17A. And more expensive, as you can see by the filing fee. And then also Article 81 does require an independent court evaluator to be appointed. So this process generally is just more complex and expensive when you compare it to Article 17A. But it's an option out there, and just wanted to let folks know that it is there. So Article 17A guardianship is pursuant to the Surrogates Court Procedure Act, and it only allows for the appointment of a guardian for an individual with intellectual and or developmental disabilities. It allows the parents, relatives, or friends to file the petition in the Surrogates Court. And then within Article 17A guardianship, you can become the guardian of the person, which generally gives you everyday decision-making authority. So that includes residential, education, and then all medical and healthcare decisions as well. Just being the guardian of the person. You can also be guardian of the property. So if your child or loved one has property in his or her name, you can also manage the property. Important note is that at the time when you file with the court, there actually does need to be property. It can't just be a hypothetical or something down the line that they might have. Like it actually has to be tangible at the time of when you apply to become the guardian, that if there is property um, to do that. And then also important to note though that if your child or loved one does have property in their name, it might be beneficial to consider a special needs trust or a supplemental needs trust, just because the property and funds in their name can affect benefits such as SSI and Medicaid. We'll discuss that a little bit later when we talk about future care planning. But just to let you know that it's an option to become the guardian of the person and or property. If you are the guardian of the property, the court is going to require you to file an annual accounting of the funds and what came in and went out of that account. Right now, there is no requirement to file an annual report if you're just the guardian of the person. Just note that. Um, so just overview. So anyone who's going to act in the best interest of your child or loved one can apply to be the guardian. So it could be relatives, parents, friends, and they can file this petition on their own without an attorney in the surrogate's court. There's only a $20 filing fee, and that's the only fee that's going to be associated with this process. And we compared that to the 210 of the Article 81. Um, and then the petition is going to be filed in the county in which your child or loved one resides. So, just for example, if they live in Brooklyn, but you live in Manhattan, we're going to be filing this in the Kings County Supreme Court, Surrogates Court. It's the county where your child or loved one resides, is the venue for this application. So, a general overview of the procedure. So, the court does have their own prescribed forms that need to be complete. Those are the petition documents, and that's what we're going to be doing in 2 weeks from now, going over all the petition documents line by line in detail. They're available on the Surrogates Court website. And another note is the Surrogates Court website does offer a do-it-yourself link that also helps families input the information onto the forms. I believe it's available in select languages for help in completing the forms, but when you print out the documents, they do need to be submitted to the court in English. So in addition to our petition documents, there are going to be 2 medical forms that need to be completed. They are also on court prescribed forms. So basically you need 2 different doctors to complete these 2 medical forms. So the first one is an affirmation of examining physician. So generally this can be completed by their primary care physician. And then the second is an affidavit of examining physician or licensed psychologist. And this form is generally completed by the licensed psychologist who performs the psychological evaluation. It can be completed by a second physician with specialized knowledge, such as a psychiatrist or a neurologist. Um, and then another important note is that in addition to those 2 medical forms, select boroughs such as Manhattan and Brooklyn require the actual psychological and psychosocial evaluations to also be submitted in addition to those medical forms. They really want a clear medical picture for the guardianship process. And then within the 17A guardianship, you're allowed to have a co-guardian. So a co-guardian would be someone who has equal decision-making authority as you do, so the primary guardian. So essentially you have 2 guardians. It's optional. You don't have to have one, but you can have one. And then there's also an opportunity to have up to 3 standby guardians. So a standby guardian acts as a backup. So if you as the guardian, if you have a co-guardian, are no longer here or able to serve as the guardian, the standby guardian can step up and become the legal guardian of the person. And that's important because in the event of death or incapacity of the guardian, the standby guardian does become the automatic guardian. Um, and they just so there's no interruption in the guardianship. So just for example, if your child something happens to you and they need a guardian, they need a medical consent, the standby guardian can serve in that role. They just need to be confirmed with the court within 6 months of your death or incapacity. But there's no interruption in the services and support for your child or loved one. Generally, guardianship is for the lifetime of the person unless the court limits it otherwise. And sometimes they have been doing that where they will say temporary guardianship for, say, if the person's 18 and they're still trying to figure out if the guardianship really is most appropriate, they'll grant it, just for example, for 3 years and say come back and then we'll re-examine it. But generally, it is for the lifetime of the person. You can always change the order of the guardianship succession. So you can change your standby or add a standby later at a later date, but you do need to go back to court to do that. You have to make it official with the court. Uh, so the requirements to become a guardian, they're very simple. There's really only four. So the person who's going to be either the guardian or a standby guardian does need to be 18 or over. They do need to be either a U.S. citizen or have permanent legal status, such as a green card. Um, they can't have more than two felony convictions and no major child abuse history. But that's really all the court's going to ask for the guardian and standby guardians. And again, it could be anyone. It could be siblings. It could be relatives. It could be a family friend. Just whoever's going to serve and act in the best interest of your child or loved one can serve as a guardian or standby guardian. So after we file all our petition documents and our medical forms with the court, and it gets processed, we're gonna have a hearing is gonna be held, and generally the court is going to ask for the presence of your child or loved one at that hearing, and they have remained largely virtual. So there's really no reason why they can't be present for the judge, just to make sure that guardianship really is the most appropriate option for them. And then just a note would be that if your child or loved one resides in like a certified residence, mental hygiene legal services is going to be appointed to represent your child or loved one in the proceeding. And what that means is basically they're going to uh,
Big.
meet with you and meet with your child or loved one, and just to ensure that guardianship really is most appropriate. Um, and they'll submit their recommendations to the court to let them know if they support the guardianship or if they have some concerns going forward. But again, that's only MHLS is only going to be involved if your child or loved one lives in a residence. If they live at home with you, generally MHLS is not going to be involved in the proceeding. So after the hearing is held and the court is satisfied that their best interest would be served by having a guardian, they will grant your petition to become the guardian. And after that, you're going to receive letters of guardianship from the court, which is basically just a piece of paper with your information and your child or loved one's information, and it says that you're the guardian with the court seal on it. So you should always hang on to that original document and then share copies with any medical professionals and service providers as well, so everybody knows um, who the legal guardian is. So responsibilities of a guardian. So guardians are granted the authority to make all medical and healthcare decisions, including life-sustaining treatment. Um, Even though you are appointed a guardian, you should always encourage and allow your child or loved one to make as many decisions as possible. Guardians have a fiduciary duty to advocate for the best interest of that person. This comes up a lot, this question. So people ask if you're the guardian, does the person have to live with the guardian? And the answer is no. Guardianship does not require the individual to live with their guardian. The guardian just must ensure that the person is receiving daily care and all the necessities that they require. Just make sure that everything's okay for where they are living. This is just the court contact information in all 5 boroughs. So every borough has their own surrogates court. And this is just their contact information that we can share after. Okay, I'm gonna transition just into the importance of future care planning. Um, so many families provide lifelong supports for family members with developmental disabilities. However, most families have not planned very far into the future. So the goal of future care planning is to engage in conversation and consider all the available options. And it's never too early to begin this discussion with your family and friends. Um, so a comprehensive future care plan involves thoughtful consideration of the needs and preferences of your loved one. And this could include exploring housing options, examining financial resources, and learning about healthcare resources as well. Um, and there's benefits of advanced planning. Generally, plans are well thought out when emotions are calm and you're not pressured to make important decisions. So helpful to prepare in advance. Early planning allows future caregivers and support to have an increased understanding of the person's preferences and needs, and allows the care and service providers to also have an opportunity to become familiar with other family and friends of the person. And it also allows family members to have a clear understanding of their role and minimize the chances of any family conflict down the road. So planning for the future of a loved one with a disability. So often people with disabilities who receive SSI income or Medicaid benefits have a difficult time saving for the future because they can only have a certain amount of money um, to their name to qualify for these mean tested government benefits. So there are common ways to save while also still maintaining your eligibility for these programs. So there's a special needs trust or supplemental needs trust. So this is a common way to secure financial for a loved one with a disability without jeopardizing the benefits. And also ABLE accounts are another tool that could be used to help a person save while protecting their eligibility of benefits. So a special needs trust or a supplemental needs trust, they're interchangeable. They're the same thing. So it's an irrevocable trust that is designed to manage funds to benefit a person with a disability while preserving their eligibility for essential means tested government benefits such as Medicaid and SSI. So the special needs trust is designed to help people with disabilities by sheltering any excess income or resources so they can still qualify and maintain their eligibility for services. So the parties of a trust. So who's involved? So there are 3 parties that are needed to create a trust. You have the donor or the grantor. So this is the person who's funding the trust. Where's the money coming from? And then there's the beneficiary. So this is the person who benefits from the trust. And then there's a trustee. So this is the person or entity that's responsible for managing the assets in the trust and making distributions according to the trust terms. These are the players of a trust. And then there are a few different types of special needs trusts. So we have a third party special needs trust. So this is funded by someone other than the person with a disability. And it can be either during the donor's lifetime or it could be part of an estate plan. But the third party special needs trust is going to be the money of somebody other than the person with a disability. A first party special needs trust is going to be funded with the money that belongs to the person with a disability. So in order to create a first party special needs trust, the person does need to be under 65. That's the law. And then there's a pooled special needs trust. So this is a trust that's administered by a nonprofit organization, and it's funded with the excess monthly income or resources that belong to a person with a disability of any age. So, for example, if somebody who's 66 and has received an inheritance money that it wasn't planned for carefully, and now they've come to an inheritance, but now they're above 66, their only option is going to be to do a pooled special needs trust. That's why it is important to plan for future care planning. So like we said, the third party special needs trust allows a third party to gift money or real estate to the person, but while they're still preserving their eligibility for benefits. So it can be established by a parent, a grandparent, a relative, or friends for the benefit of a person with a disability. So generally the trust document is going to be drafted by an attorney because it's a legal document. And there are two ways to create this. Like we said, it could be created during the donor's lifetime, or it can be, or the trust can be funded as part of an estate plan with an inheritance or life insurance, real property, or other assets as well. And we're going to need to select an appropriate person or entity that's going to serve as the trustee and manage the trust. There's no requirement to reimburse the state that provided Medicaid services upon the death of the beneficiary. Upon the death of the beneficiary, the funds are going to be distributed to the remainder beneficiaries as outlined by the trust. So again, the third party trust, there's no requirement to reimburse the state who provided the Medicaid services. So for the first party special needs trust, so this is going to be funded by a person with a disability under the age of 65. They can establish the self-settled special needs trust. So self-settled meaning funded with the money that belongs to the person with the disability. So in this case, the person with the disability is both the donor slash grantor and the beneficiary of the trust. So common examples. Oh, question?
I was just going to say, can you give an example? Because that helps me understand the difference. There we go.
Oh, no, we have common examples of this would be with the direct inheritance. So future care planning we didn't do this properly, we weren't thinking ahead, and now the person is set to inherit direct money that's going to come directly to them. There's no trust set up for them, but now they can't inherit this funds because it's going to affect or jeopardize their eligibility for SSI or Medicaid. So we would need to put it in a first party special needs trust. It could also be from settlement proceeds if there was a lawsuit and you're now receiving money. Sometimes it's retroactive Social Security or DAC benefits that become assets, but now it could disqualify you, would be an option to consider the first party special needs trust. So again, the attorney is going to have to draft this irrevocable trust document, and again, an appropriate party or person is going to have to be selected to serve as the trustee. And if this case, if the disabled beneficiary does not have the capacity to establish a trust, a parent, a grandparent, a legal guardian, someone who's acting under a power of attorney, or even the court can establish the trust on behalf of the person. What's different about this trust is going to be that there is going to be a Medicaid payback requirement up until the amount of medical services provided by the state. So again, benefits of future care planning, because if you planned properly and the trust was established prior to them receiving, for example, the direct inheritance, and it was in a third party special needs trust, there's no there's no requirement to pay back Medicaid. But if now we're here where the person has the funds and now we have to establish the trust on their behalf, and it's a first party trust, now we're going to have to pay back Medicaid to the state that provided those services. And then we have the pooled special needs trust. So this can be either a third party or first party trust. So again, when we're saying that, we're just talking about the source of the funding, so where it's coming from. So it can come from a third party, or it can be the person's own money that funds a pooled special needs trust. And generally, the trustee is a nonprofit organization with generally a financial institution as a co-trustee. So you get the benefit of having a nonprofit who understands the needs people with disabilities, and then you have the financial institution as well. And this is an affordable alternative to an individual trust, because this is not going to require you to hire an attorney to draft the trust document, because the nonprofit already has a trust document drafted. And to enroll, all you need to do is sign a joinder agreement that makes you part of the trust as well. So funds are pooled for investment and management purposes, but each trust activity is tracked separately for each trust beneficiary. And what happens to the money after the beneficiary is no longer here is generally the nonprofit organization retains the funds to support other individuals with disabilities. So we don't have to pay it back to the state, but you also don't get to keep it and give it to other beneficiaries. So what can a special needs trust pay for? So the trustee, again, the one who's managing the trust account, distributes the funds to pay for eligible items and services that are for the primary benefit of the trust beneficiary. So the disbursements must supplement and not replace services that the beneficiary is already receiving from government benefits. So an example of this is that if the beneficiary is receiving SSI, then the trust cannot be used to pay for food and shelter, because that can affect SSI benefits, because they're receiving funds from SSI to cover food and shelter. So technically, if we did that with the trust, it could jeopardize and reduce SSI benefits. The trust cannot pay cash to the beneficiary, so the trust can never write a check to the beneficiary. They can reimburse other parties, but they can't give the cash. The trust can pay third parties for items and services directly. They can also reimburse someone for purchasing items or services on the beneficiary's behalf. And generally, the trust cannot pay for gifts or expenses for other people. So it has to be for the primary benefit of the trust beneficiary. So there are some advantages to the pooled trust. So like we said, it doesn't require an attorney to draft the trust document. Pooling the funds can reduce the administrative cost and increase the total funds available for investment. And the nonprofit trustee understands benefits and the needs of individuals with disabilities. The AHRC does have a foundation. They offer two types. If you're interested, they do require a minimum contribution of $10,000. I don't have a slide on it, but the NYSARC Trust Services also provides a pooled supplemental needs program, and they have different options with different minimum contributions. They're nowhere near as high as $10,000. It could be as low as $300. But so there's options out there. And then we have the ABLE account. So back in 2014, they established the passage of achieving a better life experience. So this is also another option to help people with disabilities save without affecting their benefit eligibility. So this type of account might be best for people who can manage their own finances. or with the assistance of someone that they trust, because this is going to require you to keep track of purchases and to have receipts just in case at the end. But basically, it is an account that's tax advantage savings account designed to help people with disabilities set aside money for qualified expenses. So the person does need to be disabled prior to the age of 26 to qualify for the ABLE account. Um, Deposits into the account can come from any source, so there's no first, third parties like we see in those trusts, so they can come from anywhere. There is a maximum annual contribution of $15,000 a year, and the account balance itself can never exceed $100,000 without affecting SSI. That's still a good amount of savings that you can put into this account. But it is the responsibility of the account holder to maintain a record of expenses and the receipts to show the purchases were for qualified disability expenses. And then there's account fees that vary by program of which account you register into. But it's similar to what a trust can pay for, and you can have a supplemental needs trust and an ABLE account. They can work together. So generally, the funds in the ABLE account can pay for qualified disability expenses related to the person's disability. So that includes housing, basic living expenses, transportation, education, financial management, funeral and burial expenses. And then upon the death of the account holder, any funds that remain in the ABLE account are also going to be subject to that Medicaid payback for services that were provided during the period when the account was open, even if the funds did come from outside third parties. So that is a little bit of a disadvantage with the account but as long as you spend any money that's in that account, you don't have to worry about it being subject to the Medicaid payback. I think, yep, that's it for the general overview. So now we have time for questions.
Thank you, Stephanie. That was wonderful. Very thorough, as always.
I have a
Anybody
question. I have
Go
a
ahead.
quick question. What happens if the family moves to the guardianship? So let's say they're currently located in New York, in the Bronx, and they move to North Carolina. Do they have to go through the guardianship process within the state?
So it's a good question. So each state has their own guardianship statute and process. So the 17A guardianship is only valid in New York State. And if you were to move, you would have to see whatever state you move to's process of the guardianship. You can say, I have it in New York, you can show their documents, and then I don't know what they're going to be required of you to do because each state is different.
So the 81 would cover all states?
No, 81 is also, so every state has their own guardianship statute in every state. So even Article 81 would still have to be subject to whatever state you move into's procedure.
Yeah, two things. So, because my daughter's turning 18 already next month, is there a deadline by which I should file the guardianship, like the 17A? And my second question is, how far back can we use the current like psych evaluations that we have?
Okay, so generally the court's not going to accept the application prior to 18, but anytime after they're 18, you can always file for guardianship. There's no cutoff of when you have to do it by. You have to wait until they're 18 to actually file the application. And then as it relates to the evaluations, so generally I used to say within 2 years, but they have been asking for it to be within 1 year as well, especially Queens.
Are there any other questions?
Diane has her hand raised.
Oh, okay. Can't see any hands. There we go.
Yes, Stephanie, I just wanted to, for you to elaborate a little bit more on, like, if a person, God forbid, if something happens to me, I have somebody else in place. Now, I have my sister who resides here, in New York City. And the third person is his brother, but he resides in Singapore. What happened? What should I do?
So is so as long as they're either a U.S. citizen or have a permanent legal status, they can reside anywhere. I mean, just for practical purposes, it might be best to have somebody who lives closer, but as long as he's still active and engaged, and he can still serve as the guardian or standby guardian for sure.
Well, he would be the third person. I put my sister first and I put him third. But you know, they're close, so they will speak to each other in order if anything happens, they will discuss what needs to be done, you know, in regards to his brother.
Yeah, so that's fine. So he would have to sign the consent form, which we'll review in 2 weeks. Each standby guardian just does have to sign and have notarized the consent form. It's essentially saying they're agreeing to serve as the standby guardian. He would just have to sign it at the U.S. Embassy in Singapore, but that would be fine.
Oh, okay. All right. Okay. Well, now that I didn't know because nobody ever told me about that because they had handed me the consent form, but they wanted me to send it to him to send it back. So see, I didn't know that he could sign the consent form over there in the embassy.
Well, he has to send it back to you because you're going to need the signed original.
Yeah, I
But yeah, he
understand
can
that.
sign it there. Yeah, he can sign it there for sure.
Okay. All right. Well, that's something good to know. I did not know that. Thank you very much, Stephanie.
Sure.
My cousin and I will both inherit. What happens then? What will I do when Cynthia and I inherit land from our grandparents and parents? What do I do? Do I have to go through the process again? Does the land go into a trust? What happens? I'm not clear.
So it was breaking up a little bit, but I understand you said that you inherited property with somebody else.
Yes, from our grandparents, they purchased farmland in North Carolina, and the family's in the process now of separating the land. Everyone gets their own set of acres. And so what happens once we get the land? Do I open a trust? Does Cynthia's land go into a trust? What do I do? I don't know.
So I mean, it's a
I don't know.
consideration for you to decide, but if she has a disability and is getting Medicaid and SSI benefits,
Yeah.
it's definitely worth considering putting her shares into a trust just to protect it for her without
A
jeopardizing her.
pool trust? A pool trust, Stephanie? What sort of trust for Cynthia?
So if it's real estate, like if it's actually real estate, it would probably have to be either
Yeah.
first party special needs trust. I don't believe that it's going to be able to go into a pooled trust. If
Oh,
like for example the land was sold and now she has funds like money, then you can put that into a pooled um special needs trust.
no. Okay, we don't need, the family does not plan to sell the land at all. And our family will own their land. So there'll be no selling of the land. It would just be Cynthia's land. So I don't know what to,
I think you should consider contacting an attorney just to see exactly how that all plays into it, and perhaps
oh,
they could put that in a trust for her. I mean, if it's just land itself, then you become the guardian of her property, and then you can help manage her land. But the land's in North
all
Carolina.
right, thank you. It is in North Carolina, yeah.
Sharon, has the grandparents already died?
Our grandparents are deceased. My
They're-
elders, our aunts and uncles, and Cynthia's father, who's 90, we're all in the process now of dividing up the land between our aunts and uncles, and Cynthia and her brother, both of whom are disabled, will inherit father's land. He will pass it on over to them. So once that land is received, I don't know if it put in a trust. I don't know.
But is the father the legal
I don't know.
guardian of that? Of
Of
the
the
legal
land?
Yeah, like he'll inherit it
No,
first and then they inherit his
he
share?
will get it first. Yes, Mary, yes. He'll get it
So,
first and then pass it on to Cynthia. her brother.
So he should consider seeing an attorney to draft a will to to lay out what
Fine.
he wants to do with it.
Good, good point. Thank you. All right. So I'll mention it to him. He's 90, so he's going to fight back on that one. But thank you very much. I appreciate
But,
it.
but if he needs someone to explain it to him, an attorney could do that with him, just to explain that his children would lose it if he doesn't establish the will now to
Okay.
leave that land in a special needs trust for them. They will lose that land.
They will lose
Wait,
that land.
they will not lose it. They will lose the ability to transfer it to another relative upon their death.
Okay. Thank you, Mary. I appreciate that. Thank you. And Stephanie
Correct?
too.
Stephanie, am I right in saying that?
Yes, yeah, you should talk to the attorney, I think. It would
Right.
be-
Okay. All right. Thank you.
Jacqueline? Green?
Yes, my question is, I have physical legal custody of my daughter. Do I still need to apply for guardianship for her?
Yes,
She
so
has,
generally the custody arrangements are for minors like under 18, but once somebody does become 18, the law does consider them as an adult now. So that's why you have to do the guardianship process once they turn 18, because now they're technically an adult.
okay, she has autism. Um, so even though what you just said, I still have to go through the process of being her guard. I mean, it's just so weird because I am her mother, but yet
I know
I
this
think I
comes. I know that you're not alone. This happens all the time. A lot of parents just are like, I'm the mom, I'm the dad. But technically they are a legal adult now, so we do need that legal process just to continue so you do still have that
she,
authority.
but she cannot give permission for me to do anything for her. So she cannot make decisions on her own or anything like that. So I would definitely have to make sure that I stay as her legal guardian to make everyday decisions for her and things like that.
Yes, and that's what the 17A guardianship would allow you to do.
And so when do I start that process?
So
She'll be
the
19 in July.
So anytime, because you can file it anytime you get everything together. So in 2 weeks, we're gonna go through all the forms literally line by line. So
Yes.
and then you can start working on getting the medical forms complete, and then you can file it anytime.
Okay, she has a medical appointment coming up in April. Will I get the forms by then? And should I get the forms by then to take it to her doctor? How does that work?
Yeah, we're gonna send them out in advance, but if you send me an email, I'll send it to you so you have that one if it's for her primary care doctor.
Yes, it is. It's for her medical doctor. And where
Okay,
can I find your email?
I'll put it in the chat.
It's right there
Thank you.
on the slide.
It was on the slide, but I'll put it in the chat as well.
Thank you.
So Jacqueline, on that note, I want to share the same feeling I felt about getting guardianship for my son. I was like, wait a second, I'm his mother. I have to ask to be his mother, and you do. As crazy as it sounds. However, it was interesting because Nicholas had behavior one day and they were going to take him to the emergency room. And if he was over 18 and I had not established guardianship, and if I went to the hospital legally, they do not have to give him to me because I was not his legal guardian. So I know they would probably feel better giving him to me, said, sure, take him. But yeah, so I felt the exact same way. I also want to add in this note is, Stephanie, can you share about the HRC program for guardianship? And then maybe also share the information on the FSS contract. And then Jackie and I will explain the family reimbursement aspects of guardianship and special needs trusts.
Sure. So AHRC does have a corporate guardianship program that can serve as either the primary guardian or in a standby role. So we currently do serve as primary guardian for 27 people and about 28 standbys. So that is an option if you don't have any family members or friends that can serve in a standby role, you can consider that as well. We do get family support funding in 4 boroughs. Aside from Staten Island, we do get funding to provide the service to families free of charge to provide information about the guardianship process and alternatives. We do have we offer free legal assistance for guardianship. However, there is about a 1.5 year wait list for that, the free assistance. So that's why I strongly encourage families to do it on their own. And we do these workshops at least once a month where we talk about um, the process and then also go through the whole petition document. So this way, at the end, families are able to file on their own because again, there's only $20. That's the only cost that's associated with Article 17A guardianship, and it's just the filing fee with the court. So it's definitely, I know it's overwhelming, especially when you see all the documents, but I promise we can do it together. And it's just better than paying thousands of dollars to a private attorney.
Okay, so, and on that note, next, the part 2 of this webinar that Stephanie is hosting is she's going to go over the petition on April 9th at 10 o'clock. We will do it on Zoom and we will do it in person at 83 Maiden Lane. Stephanie actually takes page by page the application / petition and goes over. She'll say line 1, fill in your child's name, this address, and it makes it so simple. I mean, honestly, it's the best thing. So we look forward to you for joining us on the second part of filling out the petition. My second thing was, I wanted to share with you, Family Support Services also has a program called Family Reimbursement. In 2022, they made changes to the family reimbursement policy, and families are allowed up to $3,000 a year for certain items. In 2022, they added guardianship and special needs trusts to that allowable list. So you can go to an attorney if you're afraid to do it on your own and pay for the attorney up to $3,000 they'll reimbursement. You establish the special needs trust or the guardianship, prove that the attorney was paid, and you can get family reimbursement for those 2 things. My suggestion is, since you're allowed $3,000 a calendar year, which for Manhattan and the Bronx, any of the boroughs actually, it's July 1st to June 30th is our calendar year for reimbursement. You can do maybe a special needs trust first, or guardianship, actually probably more important first. And then the following year, if the same attorney, because they know you, or any other attorney, you can get your special needs trust done the following year. So you would be eligible for $3,000 one year for guardianship and $3,000 the following year for special needs trust. So that's something also as a family to consider. My family, just from a standpoint of view, we were saving money to initiate Nikki's special needs trust. But when we went to the attorney to do our own will, what she told us was we could just assign Nicholas as the beneficiary of a life insurance policy, and we didn't have to fund the money. In fact, she told us, save your money. He doesn't need it now when you're alive. So save your money and just assign the life insurance policy to his special needs trust upon your death. So that's what we did. And that was a big relief for, us as a family. And Jackie, I don't know if you want to share your experience when you created your guardianship or special needs trust, because I think what was comforting to me was hearing things from other parents, what they did before me and what I learned from them.
I think, yes, I'd like to add 2 things. One, I noticed there's several people who are in self-direction that are on this meeting. And because the budget does not cover guardianship or special needs trust, those are things you can apply to family reimbursement for, just so you're aware. Also, and Stephanie, this is more a question for you. When I applied for guardianship for my son, the 2 doctors that have to write up referrals took an enormously a long amount of time. Do you recommend that you start asking those doctors for the paperwork before your child is turning 18, so that maybe close to when they are 18, or can they not start that before their 18th birthday?
No, that's a good point. I generally recommend that families start the process around 17 and a half, because the doctors, there's a long wait to get those evaluations. I understand sometimes. And then the doctors do take long, and sometimes they don't do it completely. So then you have to go back to them. So it's a little bit of a back and forth with the doctors. So if you start asking, or at least getting the appointments ready for those evaluations around 17 and a half, then hopefully by 18 you can have all the documents and everything together. But definitely I recommend getting the medical forms first, and then at least then families can sign their own documents after they have the medical forms, because all the documents do need to be submitted within the 1 year of the signature date. So just for example, we got a medical form today, which is March 26th. So we have until March 26th of 2026 to file it. But again, right, if there's delays, or just life happens sometimes where the forms go out of date on you, then you have to kind of get them all over again. So definitely get the medical forms first, start around 17 and a half. So then this way, by the time they're 18, we're ready to submit our documents, and we still have 6 months in theory to get there.
Also, I just wanted to add a personal story. I never really understood why I would need guardianship, because my husband, my son is nonverbal, and it's right there for anybody to see. Nobody could question it. But when I took him to his podiatrist, of all people, they would not let me sign him in without seeing his guardianship letter. So it is needed. Some people just let it float when they see what kind of person you're with, but some people are real sticklers about that legally.
Right, and on
And
note, also,
that's really ironic, Jackie, because sometimes I offer my papers, at the doctor's office, and then they just say, no, we don't need it.
Right, exactly.
So I don't, that's like a two-way, I don't know, which way are you coming
You're
from?
100% right. And that's why I
Right.
always recommend that people carry, whether it's in your phone or a Genius Scan document, always have your guardianship papers available to you when you might need them.
Yeah, that's ironic. I, what you just said, that they wouldn't even let you in there. And then I always say, well, listen, have a copy on file so
Yeah.
you'll know, who I am and who you need to come to in regards to my son. But they said, no, we don't need it. We're fine. We don't need it. What can you do? But
Right.
like you said, just have it on you, scan it, have it in your phone. So this way, just
Exactly.
in case, anything comes up, then you have it, Yeah.
And where I've seen it come up too is at like a dentist. So if they need to have dental work and somebody needs to sign a consent form because they have to go under anesthesia,
Yeah,
and then
definitely.
the
Mm,
doctors want to make
I,
sure they're covered legally. So
well, normally every time I'm with my son when he goes to his appointment. So even with the dentist, if they need something, they will ask me, but they never ask for any other papers. And I've offered it, but they say, no, it's not necessary, because I guess maybe because they know me and they know that I come
they
with
know you,
him.
they're familiar with you.
Yeah.
Yeah.
I mean, it really depends. It varies by doctors and providers of what they're going to insist upon.
Yeah. I wanted to ask you, Stephanie, your other thing, I know is April 9th, right? At 10
Yes.
o'clock. All
Yes.
right. Now the one in person is also the same day.
so HRC has the capacity to set up a Zoom in their boardroom.
Uh-huh.
It will be the people who cannot attend in person can be on the Zoom and try to follow along page by page. But we also will be in the boardroom. We've reserved it, and there's plenty of space for everyone. Jackie and I will provide refreshments and coffee. So please come and join us.
And that's at 80 Maiden Lane.
83 Maiden.
Oh, 83.
Yes, adapt is 80. So 83
Oh.
Maiden Lane. That will come in a Zoom, I mean a MailChimp to everyone. But yeah, we're excited to do that second part.
Okay. You notice why I said 80 because I
I
must be
know,
with a
I
down.
know.
Because that's the first address that comes to mind. 80. Okay, 83 Main Lane. And what floor would that be?
It's the 11th floor boardroom, so I
Okay.
believe they call that 1119.
Okay.
1119. But if you just tell the reception on the 11th floor that you're here for the guardianship, she'll lead you to the boardroom.
And is it okay for me to pass the word around? Pass the information on to other parents
Yes,
who
we
are
were trying to
interested in doing?
we were trying to make it like that if you came to the first session, you could come to the second session, but I'm sure
Gotcha.
Diane, if you
Okay.
knew somebody, of
Okay.
course, we would never, ever turn a family away.
No. I want to follow your
Yeah.
suit
No,
because
we were just suggesting that you come to the first
yeah,
and then the second.
right.
If you know
Yeah.
someone who'd like to join us, please let us know.
Okay.
Diane, if you'll stand up for them, that's okay by us.
Okay. All right.
I have a question. I'm sorry to interrupt. And so it is true what you were saying because my son is 18, and recently, a few weeks ago, I went in we're getting new evals, and even though he had been to the Kennedy Center since he was like 2, he didn't know what to say. They were asking him like if he agrees to have the evaluation done, and if I'm able, like they didn't want to let me in the room. So my question is even though I don't have I'm not thinking about guardianship, the could I still do like the health proxy separate?
Yeah, absolutely.
And that so I could still come in and do the health proxy on the 9th with you guys?
Yes. Right?
Or how does
That's
okay.
part of the package, correct?
Not the healthcare proxy. The healthcare proxy, we can send you the form, and it's just a document for you to put in the information, like who they wish to have as their healthcare proxy, and then it just needs to be signed in front of 2 adult witnesses. But it's just basically a 2-page document.
Well, we'll
Okay.
send it to you, Jennifer, a healthcare proxy. But on that note, also, I wanted just to share with everyone a family experience was we had the state handicap sticker for Nicholas for the car. And when he turned 18 and I was not a legal guardian, they would not allow me to sign the application for that handicap permit to be renewed from New York State. New York City did not ask me to show guardianship, legal guardianship to sign it, but New York State did.
I just wanted to answer Jacqueline Green's question. You do not need to have OPWDD eligibility to be your daughter's healthcare proxy. Also, I'm not sure if I'm
Thank
pronouncing
you.
your name right.
Yes,
Musa
you
or
are.
Musa? I know you had a
No,
question.
Jacqueline.
Did you want to ask?
Yes, hi, good morning. I just wondered if there are any changes in when you go to open a bank account for a first party or a third party trust, what documentation exactly is needed? Because I feel like it might have changed. And does a supported decision-making certificate count as well as proof of disability?
The proof of disability for the bank?
Yeah, because they typically ask you to prove that the person is disabled. They won't just create a disabled account.
So
Can I just say something? Because I just put my son on my account. So I don't know if that's what you're trying to do or you're trying to just, because he has a bank account in another bank, but I put certain parts where I take care of his business from SSI, and that I put that in my account. But I didn't need to show proof of anything that he was disabled or anything like that. I mean, he had to be present at the bank, and he did have to sign.
Yeah, but that's for a personal account. But let's say you're opening a trust account. Let's say you have a first party trust and you want to
Mhm.
pay for whatever, new shoes, a trip to Disney World, whatever it is you're doing, and you might want to do that out of the first party trust. You need to have a first party trust that is tied to legal expenses as a disabled person. I mean, a trust needs to have reporting, right? You have to report it
Yeah,
Well,
and you
that's
have to
correct.
show
but
your
the
business.
trustee, though, the trustee would be creating this account and managing the account.
Okay, but I just thought that there was I mean, I know that they have in the past asked for proof of disability, and I'm just wondering if supported decision making
An
certificates
agreement? I
a
mean,
form of identity. You know, I just it's because
that's
this
a good
comes up.
question. I'm not sure. I mean, technically it's supposed to be binding on third parties. So if you have a supportive decision-making agreement that was entered into through the facilitation process, and for example, you're the listed financial supporter, and then you're trying to open the bank account. Is the bank gonna honor that? I don't know. But that I think that's your question.
Yeah, and also for first party trust, let's say if you don't have supported decision making, let's say you have maybe you have guardianship, maybe you don't, but you have a certificate of disability from the state or whatever. Like what have you come across as issues? Like I hear about the ones with the doctors, but the banks, if you're opening a new account, and also for ABLE, you have to prove disability, right? So what constitutes proof of disability for banks and places like that?
I don't know the answer. I
Okay.
have, no, I don't know.
All
I
right,
mean,
I'll find out and let you know.
I mean, if you had guardianship paperwork, what do you show like Social Security as disability?
I guess that would be enough, you think, yeah. It's just the world is like getting kind of fussy about where money comes from and where it's going and if it's in a trust account or not, you know, and so I'm just wondering if you had any particular insight on that. But I'll go to the bank and ask and then I'll let you know.
Generally, I don't deal a lot with financial and even guardianship of the property just because usually people have the trust accounts already established, so it's not something
Right.
with.
Yeah, but people who are about to open it, it's good to help people with precise information. But that's my job. Don't worry, I'll figure it out. I'm just wondering if you knew that, especially for supported decision making, like how valid is that document?
Good question.
All right, well, never mind. Thank you. This is very
Sorry.
helpful.
Sorry.
Stephanie, we also have a question, which I believe the answer is yes, that we can get hard copy papers that people can print out and they can do the application by hand. Somebody like myself is a technological dinosaur. So Jasmine, I believe, is asking, is that correct?
Yes, so we'll share the forms. You can print them out. They're available on the court's website. There's hard copies available in the actual surrogates court in each county. You can get them there, but we'll definitely share them.
Thank you.
Follow up on that. For those attending in person on April 9th, will printed forms be available for them to write on?
We could do that. But on that note, I would need anyone who's planning on attending in person to please let us know so we can have the appropriate amount of petitions available. Let's put it that way. One, I don't want to overprint and I don't want to underprint. But yes, Jackie and I could do that. So again, if you plan on being in person, please email Jackie and I or Andrew and Pat or Tina email somebody, say work with the person, right? Please provide us with the forms. That makes sense? That's good for everyone? And on Jackie's note about
Yes.
self-direction and family reimbursement, again, family, it's not part of the budget, but self-direction families are eligible for family reimbursement. It just has to be in the life plan as family reimbursement and stated that it's a guardianship or special needs trust. And I would budget $3,000 for that because that's the amount you're allowed.
And that money will come out of your overall budget, just to be very clear. Alva, you had a question?
My first question is, how long does the guardianship process take approximately?
So generally, I'm gonna say 3 to 6 months. It really depends, though. Sometimes just if you have to keep going back and forth with the doctors and to get the court hearing scheduled, I'm gonna say around 3 to 6 months.
Wow. Okay. And the second question is, so my son is the person that wants to be the guardian or the standby guardian for my daughter. But the problem is he lives in Florida. Does he have to come up to be present for the court hearing?
Generally, no. If they have remained largely virtual, so if it's a virtual appearance, they might ask him to appear, but no, as long as he signs a consent form and he can sign that in Florida, that's fine.
Okay, and then how do they get the consent form? Well, like they go.
I guess you would have to mail it to him, or you can email it to him and have him print it out and just have it signed in front of the notary, and then mail you the original back because the court will want the original.
Okay, so what's the difference between the standby guardian and the co-guardian?
So a co-guardian is somebody who has like the same equal decision-making authority as you do at the same time. So they would be like serving you're essentially both guardians. So either one of you can make the decision. It doesn't necessarily have to be both of you. Either one can act. A standby guardian really doesn't have any authority or power to act unless something has happened to you or you're no longer here to be the guardian.
Okay, and one last question. I'm sorry I'm taking so much time. How do I get a hold of the proper paperwork to bring to her doctor to fill out for the guardianship?
So if you email me, I can send you the medical form.
Okay.
Or at the 9th, we're going to send it out in advance because they are on court prescribed medical forms.
Right. That's what I thought. Okay.
It's a good question because they're not short.
Right, and that's part of the package though, right, Stephanie? That's going to go out to everyone. So Alva, when we send the whole package out, you'll find the medical on that.
Mhm.
And a lot of people can say that the doctors are a little backed up. I got Nicholas's signed, and twice, it was a year after the doctor initialed it and dated it, that I never even continued the process, so I had to keep going back to the doctor and say, I promise if you do it one more time, I'll file it in this year, but it was always put on the back burner.
Okay.
Stephanie, is it required to be by your PCP? Can it just be any two doctors that your child sees?
Yeah, it could be any two doctors. They just have to be two different doctors. And really the court's looking for like IQ information. It's not really about blood work or lab results. It's not that information.
Right. I asked that because a lot of our people see multiple doctors. And when I did this process, I should have not chosen his pediatrician and chosen somebody else because he was never done one before. And he was so scared he was going to get it wrong and it was going to hurt Sam that he just procrastinated for 6 months. So think about what your options are of who might be able to do the paperwork speedily for you.
Sometimes it's helpful if the primary care doctor is unfamiliar with it or doesn't feel comfortable doing it. If you have the actual psychological evaluation and the medical affidavit from the psychologist, if you show them both of those documents, then there's a box that they can check that they reviewed it and essentially just write the exact same thing.
Oh, that's very good information. Did everybody hear that? That
least
saves a lot
everybody's
of
on the
time and
same page.
anxiety.
Yeah.
Oh, I had a question because I often hear parents are paying a lot of money to do guardianship? Is it because they're going through a lawyer to do this? Because I went through the process where, like you said, I only paid the fee at the court, and that was it. But I'm hearing people that they're paying X amount of dollars just to get the money, just to get the paperwork done.
So if they hire a private attorney, it's definitely possible that they charged a few $1,000s just for their legal fees. But you don't need to do that. You can do this on your own. It's just $20.
Right.
But if you can get the family reimbursement, I mean, that's great that they offer that option as well. Because I mean, I understand it is an overwhelming process. There are a lot of forms. It's a lot of back and forth and keeping track of everything to make sure you can file it. But again, $20 compared to thousands is.
Sounds a lot better.
Right. Maria?
It's better in Spanish for me because I don't know sure if you understand my question. En cuanto a los beneficios de los niños, mi hijo es 18 años, recibe el Social Security a partir de los 18 años, pero también tiene el Child Support hasta los 21. ¿Uno de los dos beneficios pierde o continúa los dos al mismo tiempo?
Here. My son has SSI and child benefits until the age of 18. Wait, maybe I missed some of it. Would one of those be lost?
From the guardianship, I believe perhaps at 18 that do you need to recertify the SSI, or once you receive it, you keep receiving it? I'm not sure.
Well, most people don't get the SSI till they turn 18. I
Till
mean, there
they
are
turn
exceptions.
18. Yeah.
So then
My son is 18, and we haven't had to recertify yet. They'll send so he started getting SSI when he was smaller. Then we didn't qualify for it because of our income, and now he turned 18. So he has to recertify. They give them an appointment. I'm in Manhattan, so that's how it works here, from my understanding. But she did say that he'll have child support, the lady that was speaking, until he's
¿Conmigo?
22. Yeah, Maria.
Okay.
She said, hasta
until
la edad de
20.
22. Yes, hasta la edad de 22 años, ¿verdad, María? Tiene child support, el hijo de usted.
Bueno, mi hijo tiene hasta los 21, fue lo que me dijo la corte.
Oh, until 21.
Ajá.
court said.
Pero
Okay.
él a los 18 empezaron a darle lo del Social Security. Pero no sé, como estaban hablando de los beneficios que a veces afectan, quería saber si al recibir los 18 años el Social Security paran el Child Support o ambos continúan juntos.
I have a question for Stephanie. I mean, it's a legal question, but aren't there caveats if you are receiving child support for a child with disabilities? Does it still end at 21?
I was gonna say that's gonna be whatever
A legal question, right?
yeah, that's for like the judge or whatever the agreement was when you put it in place, if it was gonna be 20, 21, sometimes 26, but I think it does depend on what the original agreement.
At what age would I need to start filling
No,
out the
lo que no
application
entendí
for
es
my
que si
child?
continúa los dos o uno de los dos lo pierde.
Somebody just answered that the age is 26, according to 2 courts that they looked at, Maria.
Sorry, Jack, go ahead.
No, that's okay. Joanna is writing in the chat. So Maria, somebody who seems to know about this says that you can get the child support till your child's 26. But I believe probably legally that there is an appeal based on the disability. I don't think that that's a finite thing, but I am certainly no lawyer, just have a sister who's a lawyer. So I hear about some of this stuff. I hope that helps.
I have a question. I wanted to know at what age would I need to start filling out the paperwork for to do guardianship?
Otra pregunta que se presenta es aquí
I
va a
recommend
comenzar a
around
hacer
17 and a
proceso.
half.
Se recomienda empezar a la
Okay,
edad de
thank you.
17 y medio.
Johanna, I can
Yes.
hear you. You're part of our group now.
Oh, perfecto.
There we go. So we have Johanna Santana right with us now. So to answer that question, I think Stephanie had said 17 and a half to start the paperwork, right, Steph?
Yes.
A los 17 y medio se comienza el proceso.
But I say if you know your doctors are slow on their camp health forms, to give them extra time for this.
Y si usted conoce que el doctor es lento en este proceso, comience antes.
Johanna, did we answer Maria's question? I wasn't sure.
No, creo que no. I think no. Her concern is regarding having two benefits. Which one would be lost? And let me confirm. María, tu pregunta era cuando hagas el proceso de tutela legal, si vas a perder uno de estos dos beneficios.
Eso
So her question is if she does the guardianship, if she loses one of those two benefits, SSI or child support.
No.
If she doesn't take it, or
No,
she does?
If
does
she
guardian.
does complete the guardianship application, if she will lose any of those benefits.
Oh,
I don't believe so.
La respuesta es no.
O sea, el Social Security no le afecta con el child support, ni el child support.
No, pero como
No,
usted dice,
pero-
la corte le dio como para el child support hasta la edad de 21.
No, no, déjeme explicarla.
Mm.
Dani cumplió recién 18 años en agosto.
Ujú.
Yo cometí un error, sometí bien tarde lo de guardianship y estoy esperando porque no hay appointment para la evaluación psicológica para la corte.
So she already submitted the guardianship documents. She turned 18 and she's waiting for an appointment at the court.
Desde agosto. So,
Since August.
yes, no hay, según me dijeron, no hay disponibilidad por ahora. El detalle es que no sé, porque honestamente estoy un poquito sola en esto, no sé cómo es. Y tengo un poco de conflicto con el papá de Dani. Entonces, yo no sé si hasta qué edad en realidad es el child support para un niño deshabilitado, no lo sé.
Entonces tiene un poco, she's, sorry, let me switch to English. She's a little confused regarding the child support services and if you will be in a conflict. This question might be better answered at a personal level because there are more personal details that could make more sense to help answer the question. I can recommend that to María. Sí, María, te recomendamos a lo mejor contactar directamente a Stephanie porque tienes detalles más personales en la pregunta que haría más sentido para poder responderte mejor y así puedes tener una respuesta satisfactoria. ¿Sí?
yeah, like maybe Advocates for Children or New York lawyers could offer a legal perspective. So,
Y también puedes tener una perspectiva legal a través de organizaciones como Advocates of New York.
Ok, pero algo que me acaba de decir, ¿hasta los 26 el child support para niños con disability?
Depende de los acuerdos entonces entre la corte, el padre de los niños. Hay como detalles personales que van a ser más sencillos.
Okay.
I just wanted to say to this, Maria, that you're not alone because a lot of us who have these adult children and all of a sudden we have to do all these things to keep them to be our child. And so you're talking about Social Security, you're talking about guardianship, you're talking about switching them from maybe your insurance to just Medicaid. Maybe they'll get Medicare if you take your Social Security at a certain point. There's a lot going on, I think, at this young adult age. So it is confusing. So I hear you.
El mensaje más importante es que no está sola. Estos procesos pueden ser abrumadores y habemos muchas familias en este proceso también trabajando juntas, que no está sola.
Gracias.
Does anybody else have any questions? Not about the state of the world, but for Stephanie?
Hi, yes. Can anyone hear me?
Yes.
Hi, this is Mirandy. I had a question. I just saw Jennifer's comment about where our child could get SSI but can't maintain more than $2,000 in a bank account. What if he has a job and you're just sort of putting his money to the side and saving it in the account. Will that impact his SSI benefits? I mean,
Yes, it might be beneficial to consider the ABLE account or
Yeah.
the special needs trust. So it
I
doesn't
see.
affect his benefits.
You have to keep that under 2,000, so you'd have to put it somewhere else.
Okay.
That's why a lot of people use the ABLE account.
Got it. Okay. Yeah, he wouldn't he's really not at this time in a place where he knows to manage that on his own, but okay, yeah, my husband and I would have to look into those accounts then as Stephanie had shown us earlier. Thank you. Thank you so much.
Sure.
Solo para familias que están recibiendo income suplementario. Si la persona con discapacidad comienza a trabajar y recibe dinero adicional, usted no quiere poner en riesgo ese income suplementario, considere algún trust para que ponga ese dinero para el uso o el beneficio de la persona.
I have a
But-
question though. I have a
Go
quick
ahead.
question. Although if we take our special needs trust and they're working, obviously they're using it directly reflects on their SSI. So if they go above, I don't know, was the requirement in order for them to still qualify? Like let's say they make a little bit above what is required. Does that interfere even though it's not going into the regular account and it's going to a trust fund account? I'm just thinking about, I just thought about that. I'm not sure. That's kind of conflicting.
So if
I
there's
think Stephanie, what this is showing is we probably really need a good meeting about all, Social Security versus, Social Security in light of guardianship, in light of special needs trusts, in light of people who are working, and in light of ABLE accounts, kind of everything together.
Yes, please.
And will you do that, Stephanie?
I feel like we need another expert. Like I could talk about the trust and ABLE accounts. I'm not that much of an expert on like SSI and like Medicaid and that stuff. But
Maybe we could have a dual
like a panel or
presentation.
something.
It
for
seems like there's a
sure.
lot of questions.
But to go to the question, so if there's excess funds, so for SSI it's $2,000. So just say he makes just say 2,500. You can take that $500 extra and put it in the trust account, and as long as that's in the trust account, that's not going to affect any SSI or Medicaid. That's the purpose of the trust, is to shelter any excess income or just income that they might receive or funds that they have available to them. But it's not going to conflict if it's in a trust account.
En el caso de personas que tengan discapacidad recibiendo income suplementario y hagan un poco más de los $2,000 que se permite en el income suplementario, el propósito del trust es poder darle refugio a ese exceso financiero que puede ser usado para el futuro de la persona sin sacrificar los beneficios gubernamentales que recibe ahora.
I think one thing to remember about all of this, as we know, is that some of these Social Security rules may be changing. So we're going to have to be, keep up with all of this. Does anybody else have any questions?
No, I just want to say thank you everyone for coming. We look forward to seeing most of you, little hint, in person on April 9th at 83 Maiden Lane, where we will again provide the forms. If you tell us in advance that you are coming, we will have a package labeled just for you.
And a donut.
And a donut and some muffins and some coffee. Maybe I'll throw some Diet Coke in there. For those of you who know me. Also, on that note, Johanna Santana will also be there in person for Spanish translation. And we want to thank you so much to her, because this way we can help, all of us can get the help we need. And thank you, Stephanie.
That is in Queens or Manhattan? What is it?
Manhattan.
Okay, I'm asking
Eighty-
because in school was
80
I need go, but I need go fast to my job. So that's.
But again, it will also be on the Zoom screen, and you can follow along at home. You'll just have to print the documents, the petition, for that morning. Anything you want to add before we leave, Steph?
No, that's it. I
No?
hope this was helpful.
It
Thank you
was.
so much, Stephanie. It was a lively conversation.
And it was a great conversation. We, I think, had 58 people at one point.
Yeah.
You know?
Wow. Good.
Yeah, that is a
Good
really
turnout.
great show. Yes, definitely. So thanks for all for joining, and Stephanie, thank you, and Johanna, thank you. And thank you all for coming.
Thank
We'll
you
see
so
you.
much.
Have a good day,
Everybody,
everybody.
Bye-bye.
have a
Thank
good
you.
day.
Jackie.
Have a good day.